Hey, everybody. Welcome to week 114. Thank you for being in the waiting room. The doctor will now see you. Hopefully we didn't make you wait too long. Oh man, this will be fun. You know what the drill is. Q&A for questions, chat to harass us. And that should be okay. And we're going to go deep into examining the anatomy of a deal. Fortunately, we're going to examine the deal, not anything else. I don't want to examine anything else. So, Adam, I know that Jack has some Cliff Clavin updates. He may even have a dad joke in there. I don't know. But also, do you have any updates for us? Anything that's moving worth noting?
Yeah, it's horrible. I haven't fact checked this to see whether or not it's true or not, but evidently the number of deaths in the last 2 years from people who otherwise would have collected Social Security has tacked on more years to Social Security. That's awful. But evidently,
wow.
I heard it from a reputable source, although I have not fact checked it. So that's a long way of saying that, you know, I'd always kind of anticipated that at some point they were going to probably raise the retirement age a little bit and then maybe boost up the Social Security tax rate by, you know, 0.25% or so, because that's what would have made Social Security solvent for, you know, my generation and the generation after. But, you know, evidently, you know, enough people have died, unfortunately, that would have otherwise collected Social Security that it's gotten a couple more extra years of life left in it, which I think, you know, that runs it through maybe 2035 based on the current projections, you know, somewhere in that range.
Interesting.
Sorry to be a Debbie Downer.
Yeah, wow. Well, so I still plan on working then, so.
So top that, Jack.
Yeah, welcome to summer. Whoa.
Yeah,
I will
say, change our theme.
Yeah, I will say on that note, you know, a lot of people are like, yeah, entitlement benefits, blah, blah, blah. It's like Social Security is a zero-sum game. Like, you can't still collect the tax and not pay the benefit. So when people talk about, you know, we're totally going to reform Social Security and Medicare, you know, it's somewhat revenue neutral. You know, when you look at the federal budget, meaning like what they take in is kind of what they pay back out. So if you can't make a decrease in the benefit without having some sort of corresponding decrease in the tax rate. That's why it's the third rail, you know, of politics. So you know, that's not the place to go for budget budget work.
Well, I'll tell you that it's Social Security does not appear at any place in my estate planning down the road as being, you know, income. Be nice if it was, you know, maybe treat that as a bonus. I can go buy, you know, lunch maybe once a week or something with it at that time, if it even comes. So, all right. So the Cliff Clavin version this week of stuff. Only a few things, because I really want to get to kind of the core of what we want to start talking about. So on Capitol Hill, there was this push towards having an independent contractor rule published and through the Department of Labor. And there was and this has come up in the context of franchising, because a franchisee is an independent contractor of the franchisor. And there has always been a push to collapse that and make the franchisor vicariously liable. So basically be kind of a co-employer of the employees of the franchisee, so that the employee of the franchisee can sue and go all the way up, which is basically the exact opposite of the reason for franchising, which is to basically license the technology and the intellectual property and the processes to others and have them implement it with their own employees and with their own business. And so there was a fight, and the person that was nominated to head the Department of Labor didn't make it through the process. And a lot of it was because of the influence of the International Franchise Association saying this is going to be horrible, and the American Bar Association, more so the IFA, saying this is going to be horrible for to create a closer contact or a rule or rules that basically would bring what would otherwise be independent contractors into and under the employment of certain employers. And so they're really trying to fight that, and in fact, maybe go in the opposite direction in relation to that. And that'll impact a lot of us that, as employers that do employ independent contractors. But if they were deemed employees, then you'd have issues, or you'd have responsibilities for insurance, for other things, payroll taxes, and those kind of things that you don't necessarily want to be responsible for. There is continuing support to initialize or put more money into the ERTC fund. As you recall, that the program was cut short earlier than expected. And then they also had a cutoff where wages paid after September 30th of 2021 were ineligible for the credit. So there's all kinds of machinations between that and PPP and everything else. But so there's still that fire has the candle has not been extinguished yet in trying to get more money into there. And then in truly kind of Cliff Clavin form, earlier this week marked the opening of a new Taco Bell concept called Taco Bell Defy. And it was in Minnesota. And they have digital check-in screens with QR codes, audio and video technology, and a 2-floor drive-through. So they have hydraulic lifts that will lift your car up, and you get to go through a drive-through. Now, I'm wondering if they have a slide for the cars to come down. They didn't say that, but that may be, kind of the thing that, okay, like bumper cars sliding down. So there it is, the news that is fit to share.
Oh man, I've got some inappropriate comments for that, but I'm going to save it, especially Taco Bell and their refried beans. But anyway.
And slides, yes, yeah.
Oh man, well, let's dive into the anatomy of the deal, because there's a lot of people. It's great to have information before you need it. And that's kind of the hope right now, because a lot of this terminology becomes almost like listening to your doctor talk about, okay, so can someone interpret what you just said, help me understand in English. So that's what I think our hope and our goal is for today. If anybody has any questions or other things that are outside of the anatomy of the deal, feel free to hit us up on that too. Hit us in the Q&A and we'll get to that in appropriate times. But if you do have stuff in the middle of this thing, hit us up and I'll be monitoring it so we can address it.
All right. So, the starting from the beginning, and actually this is really part 2, but when we're talking about the actual deal, it's really part 1. Part 1 would be what happens prior to getting more formally into the negotiation process. So we're kind of picking up at that point. Prior to that would be, and we've talked about this many times, about getting your business prepared, more sexy for potential prospect buyers, cleaning up the back office, cleaning up the financials, getting, trimming the fat kind of things. And so all those things, and then, kind of ultimately culminating into potentially evaluation of the business. So an appraisal, so that what the starting point is. And then you're going out and you're soliciting offers. So this is, we're picking up from a point where you have a potential suitor that you've selected, that you're going to accept moving forward and see if you can put together a deal. So the concept of the letter of intent, and it's called other things, memorandum of understanding, letter of understanding. But basically it is a mechanism to bring the parties together. There's been discussions, there's been presumptions that have been made in those discussions. And so let's put something on paper to make sure that we are going down the same pathway. There's still a lot of negotiation that needs to be done, but let's make sure that the fundamental terms and conditions are the same or similar for us to be able to move forward. And so while it is non-binding for the most part, meaning that there is not a commitment to move forward with a transaction, there are certain commitments that are in the letter of intent that are binding. So, and we'll go through that. I actually have, I'm going to share my screen in a moment and have 3 different examples of letters of intent that have been hopefully fully redacted. But the stock purchase, an asset purchase, and then an asset purchase in relation to a franchise asset purchase, which is a little bit different because you have other considerations, and it's just a different format of our letters of intent. And so what you're doing is, and it could be that you're taking things that are written on a napkin, taking things from emails. A lot of times when it comes to us, it is, here's the bullet points of the deal. Now make it a little more formal so that we can sign off of it and make sure that we are in the same ballpark, same universe. And so I'm sharing my screen. Okay, so first thing is that, let's see, all right. Is it up now?
There we go.
Okay.
Yep.
All right.
Now we're good.
So apparently I was saying the same thing 8 years ago around this time, that same things that we're going to talk about now. I am a little bit disappointed in realizing that my hairline was already receding that long ago. I thought it maybe it was more recent phenomenon. But the canopy is going really well, so, and I still got that going on, so it's all good. But basically, if you were to read through this article, it is very, very general in talking about what letters of intent are and the reasons for them. So basically what I've just told you in the last few minutes, but it is on our website if you want to take a look at it. So what I want to do is, let's see, let's start with, not with that one. All right, let's start with an asset purchase. All right. So really a lot of times what we'll do is we will, if we represent the buyer, we'll draft a letter of intent from the aspect of a seller. So there is not necessarily a standard or a required, that's what I'm looking for, required format or who sends what. It's typically the buyer saying, hey, seller, here's the offer that's on the table. And so you see that you put the buyer's letterhead, you address it to the seller, and then you go through this. And so you start out with, this is the parties, this is what's going on. In this case, it's an asset purchase. That's a really, it's glossed over, but a really big deal. And then, and Adam can talk about this a little further as far as the reasons why you would choose a stock deal versus an asset deal. And we've talked about that before, but have him give you a recap of that in just a moment. But so, you put in here, what are the basic terms? And again, assuming it's an asset purchase, what is the closing going to occur? What is the purchase price? That there's a definitive agreement. So this is not the end all be all as far as the terms and conditions. Again, it's just to make sure there's a meeting of the minds. Purchase price adjustments, essentially. So, are there things that are going to be assumed, not assumed? Are there things that, so any kind of variables put in there. Non-competes and non-solicitation, what are those terms and conditions? It may be that you have a seller that says, yeah, and let me take a step back. And from my perspective, a restricted covenant, non-compete, non-solicitation in a transaction is basically you're benching that person for a period of time. And is it for a lengthy period of time? Is it for a short period of time? Sometimes it has to be very specific because the seller may be continuing on with different aspects of the business, but is going to sell you a part of the business. So it has to be very much tailor-made. And a lot of times you want to do that in the letter of intent just to make sure that that's the case. Employment agreements, are there people that are going to be employed afterwards? Are there offers that are going to be made? Are there required people that have to join up or else the transaction doesn't occur? So if you have someone that is a key employee that is imperative to the success of the business post-closing, you're going to want that as a requirement to close, the obligation to close, to have an employment agreement in place with that person. And then any other conditions, due diligence. So this is where kind of the starting point. You've done some preliminary due diligence, obviously, and I'm talking from the buyer's perspective. And so you've done some due diligence and you know, obviously, kind of what the offer price is going to be. You may have seen some financials. Hopefully there's a non-disclosure agreement in place in relation to that. And so now you're going to say, okay, well, that due diligence will continue. It's maybe pursuant to a specific NDA, and you put that specificity in the letter of intent, and that what is the time period associated with that. In more complex LOIs, it'll say things like you have a 60-day due diligence and there is a $25,000, $50,000 deposit. And on the 31st day, that if you have not terminated the LOI, then we get to keep that money. And if we meaning the seller, if the transaction closes, then that's applied towards the purchase price. But if not, that's the penalty for not proceeding with the transaction. And so that calculation, and a lot of times you have to be careful. So if you go back and you say, okay, what is the effective date of this? And in this form, it's probably at you know, what makes it effective is, and there should be more, I think I redacted a little bit too much, but it is, what is the triggering date? And it's usually the counter signature of the seller saying, I accept your terms. And then that starts a waterfall cascade of timing. And you should know, and a lot of times I will say, okay, this is the end of the due diligence date, and I will calendar that, because you don't want to step over that and miss that. I've had some clients who went through, this was a couple of years ago, letter of intent, was going through the due diligence, was going to tell me after the fact that, yeah, we're good to go ahead and draft the document. And then they found something out on an environmental issue and they said, we don't want to do that, but the time had passed. And so we're fighting over getting their money back. And at the end of the day, they didn't get their money back because it was very clear that either you do or you don't. And you can terminate for any reason during that period of time. And so we go on confidentiality. We've talked about agreements pending the, you know, if there's other things that need to happen. So you want the seller to continue doing business. You don't want them to reduce inventory so that you're behind when you pick up moving forward and selling stuff. There's nothing on the shelves to sell. You want to make sure that, so that's why you conduct the business in ordinary course in a manner consistent with past practices. Use best efforts to maintain relationships. So you don't want to basically say, okay, well, you know, the seller has to be your biggest cheerleader as a buyer, essentially. And so they can't be talking smack about you during this process. And then exclusivity, a lot of times that's called a no-shop provision. And it is basically that we have you locked up, seller and your owners, that you can't talk to anybody about anything. If you have other offers that come at you, you need to let us know and let us know the details of that offer, because you know, we don't want time to kind of run that the seller is slow moving and we basically say we're done, and then they sell the business to someone else down the road and are just kind of waiting for time to pass. Public announcements, the buyer wants to be in control, or at least in mutual joint control, but certainly the announcements as to who finds out about the transaction that's going on. Worst case scenario is having a seller's employees find out something is happening from someone other than their boss, and then them wondering, why is the boss selling out? Am I going to have a job? Am I going to be out of a job because the buyer has someone that is going to assume my responsibilities? So that needs to be really controlled. well thought out. Each side pays for their own fees and expenses unless you otherwise allocate it. And then was the process for termination of the letter of intent? And usually there's kind of three ways that happens. You enter into the actual definitive agreement, whether it's an asset purchase agreement or stock purchase agreement. There's a mutual agreement, or just the passage of time if it doesn't happen. And then which law prevails? From my perspective, buyer has the money, the buyer's law, state law should prevail. Sometimes if you're buying, it's an out-of-state buyer and there's a facility, real estate involved, there's employees involved, you may agree to use that domicile state. So if it, Michigan, the facilities in Michigan, Kentucky, where it may be. So that is, and so that's kind of a very basic letter of intent. And I want to show you kind of the differential that occurs with maybe a stock purchase, which is a little more in detail. And then I'm going to ask Adam to tell you why you would choose one way or another. But as you'll see, a little bit different format. You're talking about, more of in kind of a mergers acquisitions nomenclature about a target. So you're targeting the ownership and to take over that business versus purchasing its assets. You can still talk about, the seller, the buyer, et cetera, but you're really acquiring the ownership of that entity rather than the entity. So we talk about the form of transaction, the consideration. So basically the purchase price. Sometimes it's okay. So you see that it's dollars, the cash consideration. It may be a rollover, so that the owners of the seller company are going to get, as part of the consideration, ownership in the buying company or ownership in a new entity that is where the old company is going to live moving forward. And so that's where they're putting all that. So a lot of times there's that. And then you talk about escrow shares potentially that is maybe related to an earnout. So you will get more shares in the new entity upon certain performance metrics being achieved post-closing. Because you're dealing with shares, you need to have securities law considerations in place, whether you're exempt under federal and or state law, or if you're going to have to jump through certain hoops in relation to those transfer of shares pursuant to federal law, and then the commensurate state law provisions. So that's why you have things about securities compliance. Again, talking about the definitive agreement, you always want to make sure that it is very clear that there is something more to come that has a lot more details, and that this 3, 5, 7-page document is not the truly negotiated arrangement between the parties. And then, we talk about customary conditions as we did in the other one. So approval by boards of directors, shareholders, completion due diligence, no material adverse change. And then we talked about maybe some other provisions, which is employment agreements by key employees with the new employer. And then sometimes you have to have a legal opinion to make sure that there are no tripwires with how you're proceeding. So you're going to want to have that, for example, an opinion that it is a tax-free reorganization if that's what you're going through. So certain things, business as usual provisions, as we've talked about, that use best efforts to make sure people stay on the payroll post-closing. So you deal with that. Due diligence, indemnifications and escrows, that you may want to make it clear that, again, whether it is an escrow in relation to getting to a certain point in the due diligence, or if it is that there is going to be post-closing monies held for an indemnification provision that says, hey, if we buyer find out that you seller screwed up, or that you lied in the document or lied to us otherwise, we're going to come after you for that. So that's the breach of the representation and warranty. Indemnification is the next step, which is, and we're going to pay you for it and make you whole for the mistake, for the breach, for the lie. And then you have the escrow, which is the money. So you have the underlying obligation, the link that says we promise we're going to pay, and then you have a pool of money to pull from in order to deal with that. And so these are things that you're going to want to make sure everybody's under the understanding that, hey, buyer, or hey, seller, you're not going to get all of your money at closing. There are cases where that those aren't discussed. And as I said, sometimes we'll get these letters of intent signed. I got one day before yesterday, fully executed. And there were things that I would do a little bit differently. Not a big deal in that instance because it was a current franchisee buying other franchised units from a retiring franchisee. So it's very similar. And so there's not a whole lot, and there's no leases, there's no real estate to be sold. So I was okay with that. But if it was a more sophisticated deal with more variables, I would want to be viewing and suggesting certain things in the letter intent that sometimes don't appear. And it's just because you're not thinking about, as business owners, you're not thinking about those things. You're thinking about, okay, the business is selling the business, but obviously for CPAs and for lawyers, having gone through this, we know what's coming next, and we want to make sure that everyone is on the same wavelength on certain issues. So it isn't, you're not accused of well, you're sandbagging me. You waited until after to bring this up. So for example, that if you just say the purchase price is X million dollars, but you don't talk about, oh, well, it was meant to be a 5-year installment note at this percentage interest rate. And oh, by the way, for the cash part of the purchase price, we were going to go get SBA funding. So obviously the whole transaction is contingent upon us getting SBA financing. That is something that should be definitely in the letter of intent. And maybe you wouldn't be surprised how many times that doesn't happen, because there is a presumption by the buyer that the seller knows that, hey, I don't have a couple $1 million laying around, so I'm going to have to go get funding for that. And then the seller funding on top of that, which is the promissory note to the seller. So those things just need to be worked out, I think, earlier than later. The no shop provision, as we've talked about in the other one, confidentiality, public announcements, how you get out of the deal. So the termination, governing law, what is binding, and then these are just, and we should talk about the breakup fee. So in the instance that the transaction doesn't occur, then there is a penalty. And there are really two types of penalties. One is that, hey, buyer, we understand, we as seller understand that there may be reasons out of your control that you may not be able to consummate this transaction. Maybe it may be difficult to get board approval or shareholder approval for a stock purchase or an asset purchase by the board of the buyer. And so what you're doing is you are monetizing the risk that that approval doesn't occur by saying, here is a fee that we will pay to you, seller, for all of your efforts to cover your attorney's fees and everything else if we cannot complete this transaction. So it's kind of like a reverse deposit, essentially. And then there are another form of it, which is that it is truly a penalty, but it's not because something, it's not an acknowledgement that it may not happen. It is an acknowledgement that in the event it doesn't happen, we think it's going to happen, but if it doesn't, then here's the fee for that happening. So it's not that the buyer can say, yeah, sorry, here's your money kind of thing. It is, hey, sorry, we can't get the government approvals. We can't do this, something that's out of the control of the buyer and out of the control of the shareholders and the directors. So may not have articulated that quite succinctly, but basically understand that there are two kind of, for me, versions of a breakup fee, and depending on what is agreeable between the parties. the registration rights deal with the federal laws with regarding certain things that may need to be done if you don't fall under exemptions. And so that's kind of where we're at. And then a quick variation of that with a franchise is, I just wanted to show you a kind of a different format, but same thing. I mean, you're seeing the same things that you want to talk about and make sure that people are in the same ballpark and the same universe. And in this one, it's here are the things that have to happen prior to or creating an obligation for the parties to close. And you have to go all through these things. And in this one in particular, there is discussion about either assuming the current leases or entering into new leases that are in the sole satisfaction of the purchaser. And then also in this case, because it is a franchise, consent of the franchisor, and also entering into a new franchise agreement or assuming the prior franchise agreement. But again, all in the sole approval of the purchaser. You don't want to have a franchise agreement or a lease that is acceptable to everyone else. And so therefore it's within the parameters and you have to proceed with it. You want everything to be in the purchaser's discretion and approval. Again, indemnification, what's binding. So in this case, you have explicit access to the financials that continues. You have confidentiality, retention of employees. This one is interesting. I had a discussion with opposing counsel on this last week, and I use this form, which is the seller agrees to use commercially reasonable efforts to encourage current employees. And so the seller's counsel came back and said, well, we can't guarantee employment even during due diligence or afterwards that you're going to hire them. I said that, well, that's not what that says. And so I had to add, provided, however, seller does not guarantee. So exactly what I just said, put it in there, which is basically being redundant, but okay, it got us to sign the document and move forward and got us, across that hurdle, which I don't think should have been a hurdle. I guess I shouldn't say that because it's being recorded and maybe that lawyer will see this. So anyway, a lovely lawyer on the other side. So all good. So anyway, just, kind of a walkthrough of 3 different letters of intent types. But, Adam, if you want to kind of take a step back and just maybe the top reasons to or not to have an asset transaction or stock transaction, just on maybe like on a higher level or however deep you want to go into, I think would be
Sure.
appropriate.
Yeah. So pursuant to code section, just kidding. I'm not going to do that. So I'll hit on kind of one thing, to Jack's point about a couple of things that you typically see missing from an LOI that should probably be there because they come up as very contentious issues later on down the road. But with respect to the tax considerations, Jack showed you the 2 forms, asset purchase versus a stock purchase. And what I would say is, based on my experience, I think Jack would probably say the same thing, is that we rarely ever see a stock purchase that ends up being treated from a tax perspective as a stock purchase. So, we get these letter of intents all the time, say, hey, Gary, we want to buy your company and we're going to buy the stock of blah, blah, blah. It's like, it's coming. There's going to be an election to treat it as an asset purchase, or there's going to be an election to reorg, or there's going to be something that's coming. So from the buyer's perspective, why would I want to do a stock-based transaction? It's really for one reason and one reason only. Your federal tax ID has value. That's it. I mean, for all intents and purposes. I mean, there may be other reasons, but the most predominant reason in my world is that the tax ID itself has value because it's associated with the registration of a something, whether that's a Medicare or Medicaid license, registered with the state to do something, it's all, I don't want to have to go through a process of having to, get reapproved by supply chain at Bank of America, because there's a reason. And it always comes down to, I don't want to have to mess with an EIN change when I take over this company, based on my experience. So they say they want to buy the stock because they want to keep your EIN, and that's the easiest way to keep your EIN. But on the other hand, they still want tax deductions, because when they buy your stock, they don't get a tax deduction. When they buy your assets, they get tax deductions because they get to redepreciate all your stuff. And, anything that is left over as part of the purchase price over tangible fixed assets and stuff like that I can really touch is treated as goodwill that's amortized over 15 years. So I get a tax deduction that roughly corresponds to, as I'm typically paying the debt, for what I paid for you. So that they're looking for tax benefit that's something other than increased basis in your stock. So rarely do we ever see a pure stock transaction, regardless of what these things say initially. So point number one of what's typically missing from these letters of intent is tax treatment. Even if it's a stock transaction, what's the tax treatment? Because that's going to potentially material. If you're an asset heavy business, it's got zero, heavy equipment, zero tax value in your heavy equipment. That's a massive freaking difference in terms of your net proceeds between a stock transaction and an asset purchase. My business is a CPA firm. I don't have a lot of fixed assets. For me, it kind of doesn't make too much of a difference. But equipment intensive business, it does make a huge difference. That's point number one. And if it's a C corporation, it's a massive difference. I think so that's generally why people would pick one or the other. I mean, as a buyer or as a seller, you'd always love it if it was your stock, but that's not the reality of what happens, despite the buyer sitting across from you at the table, nodding there, yeah, we're buying your stock, we're buying the stock, we're buying your stock. That's because they haven't talked to their diligence team yet to hear that they're going to need to change something down the road. So they're not lying to you, but they also don't know all the facts. So they're giving you the best information that they have at the time, which is a stock deal, but rest assured it's coming. They're going to ask for a different tax treatment. So it's better just to get that out ahead of time, because otherwise you're going to be asking for additional consideration to gross up for the tax difference between the two ways it's going to get taxed. And you'd rather do that up front rather than at the 11th hour as you're ready to get the deal done, because that does mean the buyer is going to need to pay more for the company to pay for the tax difference to you. That's number one. Number two, to Jack's point about the stuff that's missing, the two things that I've seen that I've never actually seen in letters of intent that, Jack highlighted one of them, I'll highlight the other. They really should be there, or at least bring them up so that we could in an email chain. So we discuss this, in an email chain, even if it doesn't survive the letter of intent. Jack nailed it. The whole, hey, by the way, I couldn't get the money pulled together, so I got to back out of the transaction. That literally just happened last night to one of our clients, and it's like, I told a client who was a seller, I was like, man, you wouldn't think that you'd need to ask the company, hey, y'all got the money for this, right? Because it's a $100 million transaction. Like, you don't think that you need to say, hey, y'all are going to be able to get this financed, right? It's like, actually, I even did, and they said, yeah, but then they didn't. So deal's off. So I think, but yet this guy has incurred a lot in terms of expenses and time. So it really highlights that whole breakup fee thing that Jack just hit on, that I don't know. I mean, this guy's kind of got egg on his face with his other investors that he's got to go back to now. His other investors have already spent the money they were going to get that now they're not going to get. So it's like, at least be able to go back with a couple $1 million, say, hey, we didn't get sold, but at least we got this, to recoup our costs and, to deal with our unmet expectations is something that's number one. And number two, which was also the case with this particular seller, but I see it happen all the time. So, you get this letter of intent, it's based on historical financial performance that you've provided at some point, but you're still operating the company with current financial performance. So, rest assured, if you miss a beat on your financial performance, you are going to be asked to change the purchase price downwards. However, rarely does the buyer say, oh man, you guys really hit a home run, I want to give you more money. Instead they'll say, oh, that was all factored into the multiple that we chose to give you. It's like, well, that's kind of bullshit, don't you think? Sorry, I said I wasn't going to swear anymore. I didn't do too good. So, I think, if not in writing, at least something in an email that sort of says something around, by the way, our forecast is expected to be a lot better than the 12 months that you're considering, and because that's all they'll come back to. It's like, well, I would like some more money, in the LOI. Well, all we've got to go off is historical performance. These forecasts are great, but we've got historical performance. And then you actually hit your forecast. Never do they come back and say, oh, we'd love to give you more money. Instead, they say, well, that's why we're giving you such a high multiple. They're not really, like nobody ever went to their shareholders for a vote to say, we're going to pay above market for this company because our forecasts are great. They don't. They pay market, period. And market usually is plus or minus 10, 15% of each other. Just like selling your house, it's not really that much different. The market is a market, a little bit more subjectivity, but not much. So I think the other component that again is typically missing, is also, if you have that downturn or whatever, and it's due to forces that are outside of your control, like supply chain, customer delayed the start of something. Rarely do I ever see buyers say, oh yeah, we'll consider that and go ahead and pay you for it. Instead, you get this, oh, well, that is what it is. But at the same time, it's like guaranteed money for them, that had you actually performed the work, they wouldn't have gotten the profit for it. They paid for it. So in other words, like if Jack was my customer and I had a contract with Jack that was set to start $1 million contract that was going to generate $100,000 in EBITDA, and Jack says, hey, look, I got a delay on my part, and I've got a 5 multiple. So Jack's $100,000 worth of $500,000 to me as a seller. That works. If I get a purchase price adjustment down because Jack delayed a start, and it's guaranteed Jack is going to start contractually, he just needs a delay, so it's not in my numbers, like I should get paid for that or I should get paid something for that. Yet all the time buyers are like, no, that's deferred revenue, no way. Can we do that at all? So it just, those are the things that I typically see. Wow, that bites you at the last minute. That would be great if they were on the table up front as part of a letter of intent, or to the extent that you can't make them part of a letter of intent, to at least have the discussion early on so that you have kind of a meeting. Hey man, remember we talked about this, here's the email thread where we discussed this, no last minute shenanigans on your part.
And relatedly to that is in not just work to be done, but for example, a manufacturing company, and there's warranties that are out there. Who is obviously I shouldn't say obviously, but in most cases, the seller no longer has the ability to implement the warranty work because the buyer now owns all the stuff. And so who is going to be responsible for that? And what is the length of time? So a lot of times you will have adjustments that will say, okay, if there's a warranty claim, then, or a reserve that is put into place, money that's held back, that is a separate pool of money to deal with warranty work that was caused or generated by production of goods that occurred with the seller. And so there are those things. And so it really, yes, there are things that come up after the fact, and because of the way things happen over the course of time, that are going to make a difference in that purchase price. And I'm not suggesting that everything be negotiated in a letter of intent, and it's easy to get sucked into doing that, which is, okay, and what about this and what about this? Well, I just want to make sure that everybody's on the same page with these things. What practically happens is that through the negotiation process of the definitive agreement, usually an asset purchase agreement, that those allocations and those risks are made to buyer or seller. And so while you take on a certain financial risk, the buyer says, okay, I'll take on this risk, but not this one. And so you start literally splitting up the potential problems or potential challenges, hurdles that come up post-closing as between the two parties, and who's going to be responsible for those things. So that's, again, another way of in the negotiation process and the definitive agreement. But sometimes it is important. So if it's a key component to the business and there is possible variation post-closing that really would tip the financial picture retroactively or retrospectively, that it is okay, well, if we had known that that was going to happen, there should be an adjustment. So it's again, those kind of things that it's just business owners know their own industry and they know where kind of the weak points are, and it just needs to be addressed a lot of times in a definitive agreement rather than the LOI.
So I've got two questions. One has come in from Robert Mayetta, and this is really for you, Adam. Do tax loss carry forwards come into play with a stock purchase? So that's the first one. I'll get the second one.
Yeah. So, Bank of America ruined it for everybody. They I think when they bought Boatman's Bank, no relation to me. I wish it was. They missed an S and then there's an E in it's min instead of man. Dang it. Part of what made the deal attractive was this massive net operating loss carry forward that Bank of America was willing to use. And then the IRS, after that transaction, the IRS said, oh, nay. So to that point, NOLs do come, net operating loss carry forwards do come into play, but A, they're limited, so you don't get the full value of it. And B, you have to actually continue on in the same line of business. In other words, like, if Gary operates a restaurant with an NOL and I manufacture hair dryers, I don't know why I just thought of a hair dryer. I can't go acquire Gary to use his NOL. Like I have to be in the restaurant business to really be able to utilize Gary's NOL. And even then it's limited. I don't remember the exact percentage. I think it's maybe 25%, but the NOL is limited. So it's not the same way that it used to be back in the old days before Bank of America ruined it for everybody.
Yeah, good question. So Jack, this next question is really for you. I've seen it, Adam's seen it, you've seen it. The scenario is this: offer comes out of the blue to a seller who wasn't necessarily thinking about it, but all of a sudden, hey, I got this letter of intent. We need to move on this because we've got blah, blah, blah. Hurry, hurry, hurry. Oh, is it binding? No. It's letter of intent. It's just, just formalizing. Okay. They sign it. Then they contact you, Jack, and like, hey, I signed this thing. And then you find out, oopsie, we got some stuff in here. Or, sometimes like in your example, not too bad. Other times damning, quite frankly. And we've seen that. For anybody listening on this, like this is where the ounce of prevention versus, is worth more than the pound of cure. All right, if I'm going to do this right, I got this pressure. These guys are coming at me. First of all, that's kind of a warning sign if somebody's pressuring you. But nonetheless, hey, it sounds great. They have all their reasons and it sounds logical to you. I'm going to call Jack. I'm going to call my M&A attorney. If it's not Jack, but it should be Jack. How much time do you need to turn something around? And what's that dance look like? Because I think a lot of times people feel like, oh man, I'm going to go ahead and engage an attorney. It's going to take for freaking ever. And then it's going to cost me a boatload of money. This isn't that binding. It shouldn't be a big deal. It's just formalizing, right? So walk us through that. Realistically, what should somebody expect?
So a couple of things kind of wrapped up in there. And so the first thing is so you have a letter of intent that was signed in a hurried fashion. and we get a hold of it, and there is some big issues or some things that we've talked about that are not addressed in there, but we know are issues for the client, and whether it is we're on the buyer side or seller side. And so I will have a discussion with my client and say, without being hopefully without being condescending, I told you so, you're a dumbass, but I love you anyway, none of that. It is more of, okay, understand that you guys may not have thought about this, and it looks like that maybe there was an attorney on the other side and you guys, the business people, got together, but here are the issues, and you need to have a discussion with them, and I will have a discussion with the attorney. The attorney on the other side is usually like, yeah, okay, it's one of those that they didn't contact either of us. And yes, it is appropriate to make some modifications, either specifically amend the LOI to deal with those issues, or at least have emails back and forth to address those issues, so that we don't get further down the road and say, okay, wait a minute, we have an impassable issue that we're not going to be able to close this on. And most of the time, in fact, almost all of the time, the other attorney is okay, because they've been in that situation before, and they've been on the worse end of that, meaning that the way it is now is worse for their own client. And we've been on the winning side, that haha, it says what it says, so we're gonna do what it says, kind of thing. And so, it's more of a, and there have been some more adamant people, and it's like, well, they signed it, and I'm like, okay, well, I mean, ultimately, if it's the seller counsel that's saying, well, they signed it, it's like, okay, well, I guess we'll just terminate the letter of intent right now and give us back our money. So that's maybe the reason why people are more friendly and willing to do it, because it's like, okay, the buyer has the ultimate trump card, which is, we just won't do the transaction. Good luck with that. And so as far as moving forward, it depends on the level of sophistication of the deal and the amount of data that needs to be shared and reviewed. And so, for example, in a smaller deal that was just maybe buying, one or two franchise units, there's not a whole lot of information that needs to be shared. There is obviously financial data. There is other data that needs to be shared, but we don't need to set up a virtual data room. We don't need to send them a 10-page due diligence questionnaire about, and we still want to know a lot of this information, but it can be less formal. We don't have to have them upload documents into a virtual data room. Now, my perspective on that is, in this day and age, since it's so easy to do, why not? Like, why not from the get-go have the seller put the financials, put the prior tax returns, all those things that you're going to want to see in due diligence, just put them in there, so that nobody has to go back and look through their sent box or their inbox for an email that has attachments in it. So I'm a proponent of using that, and we don't charge our clients for that because it makes our lives easier in getting through the transaction, ultimately getting to closing. So you have those components of it, and then it's a matter of, and I say this, and this is a statement against my interest as a drafts person charging clients money for drafting documents, but we're not reinventing a document every time we draft a document. As you see, we have various forms of LOIs. We also have various forms. The trick is to personalize it and to not get academically lazy, especially towards the end of the boilerplate, that maybe there was some provision in there that said, for example, maybe the governing law was North Carolina, but a neutral site was chosen, like New York, for filing complaints and adjudicating any issues. And if you don't read it and realize it says New York instead of North Carolina, that's going to be a problem. So we are taught to, I was taught to many years ago, decades ago, and I tell this to my younger people, you attack the form, whether it's our own form or it is someone else's form that's coming our way, you attack the form and put yourself in the position of your client in having to either enforce or defend against certain things. And so as far as how the transaction, the timing of that really is dictated by the parties. How quickly can they populate that data room? How quickly can they produce certain things? How quickly can they get whatever approvals are needed? How quickly can reasonably get the approvals of the landlords to transfer the leases, kind of thing. If it is a retrofit, then you have to deal with governmental agencies, fire inspectors, building inspectors, those kind of things. So, Adam mentioned this before, which is dealing with the unknowns and dealing with it on the sale price and the financials. You also have to deal with that on timing issues. And so it's not really necessarily a force majeure event, but it's something that's out of your control. There was more of this in the past 18 months or so than prior to, and it's slowing down a little bit, but a lot of provisions in the force majeure, if it's not in the force majeure provision, it is a separate provision that says that, we are not responsible for losses potentially occurring because of a delay of opening or a delay of these kind of things based upon events out of our control, specifically that understaffing of governmental agencies and those kind of things. And sometimes we get very specific as to what that means and what the consequences of those are. And it also impacts the ability for either party to terminate the letter of intent or the agreement at that point, if it's entered into an agreement. So the timing is variable, but and it depends a lot of what the deal is, what the transaction is, but also what dominoes need to fall prior to getting to a closing table, more so figuratively these days than literally. Back in the day, we're literally at a table in a conference room walking around signing stuff. Now it's all via DocuSign and other things. So yeah, that's kind of the typical timing. So I can't tell you, yeah, this type to transaction, it's 30 days. This one's 60 days. This one's 90 days.
Now specifically on the review and rebuttal before I sign a letter of intent. I understand data rooms and all that kind of stuff for the deal, right? But the letter of intent, besides, hey, we had drinks one night and we're like, hey, let's get married. Let's do this deal. Between that and, the closing, which we'll have to do in another week because there's so much into this. But just on letter of intent, I mean, I know of someone that thought, oh, well, they can turn it around in a day. Probably not.
Yeah, we need a little bit more time because it is, you would think that, okay, certain deal terms, you plop it into a document and the rest of it's boilerplate. Somewhat true. I mean, you saw kind of like there is a cadence to a letter of intent, regardless of what form you're using. But a lot of times it is, well, we hadn't thought about that, or yeah, let me get back to you after I tell the seller that we were going to get SBA financing. And then there's discussion about that. And then it's like, okay, well, we're willing to roll the dice with you. And if you get financing, but there needs to be a penalty that is understandably less than if you ditched us, if you jilted us, but if you can't proceed with transactions. So whether you call it a deposit or a breakup fee, those are the kind of things we think about. Sometimes we find that there has not been enough due diligence done. It's like, okay, well, there's certain presumptions that are made. And when I ask the question, how did you come up with that value? Well, I'm in the business and I know a buddy of mine sold a similar business, and, and you find out that you peel back the layers, the businesses are not similar. The financials are different. Maybe that owner was not taking out as many owner perks, whatever it may be. So it really is in the books different than what appears on the Facebook page for each of those entities that may make them look similar. So you got to go back and deal with those kind of things. And so there's a delay. You really don't get to the point of drafting a letter of intent until you can usually give me a bullet point list of things that you've discussed and negotiated, and then we put that into the form. So, I mean, if there was a need to right now at noon, get a letter of intent out the door by this afternoon, and I had all of the elements that I needed, that could be done. However, the likelihood of having that bullet point document the way and everything that's been thought of at noon today from a conversation that happened over a beer last night is 99.9% unlikely that everything has been thought of. So it's a matter of, and then it's like, okay, well, we can't, they didn't share stuff with me because there's no NDA in place. Okay, let's draft the NDA, and then that gets negotiated. So there are things that push back the timing of actually getting a letter of intent out the door, and then the negotiation of the letter of intent, as we talked about. You know, is it okay? Is the attitude that we need to be very specific here at this point to make sure everybody's on the same page? Or are we just basically going to say, okay, we've got the fundamental terms agreed to, we're going into a trusting relationship, and we'll figure it out down the road. In worst case scenario, if we don't, then we just break up and buyer gets the money. And maybe if there's no breakup fee, no harm, no foul, which is not true, because once you get into that mode, and we talked about this a few minutes ago, the seller employees find out you're on the block for sale. That's like, okay, maybe I need to go find another job. You know, and if, you know, vendors find out, that has to be handled very carefully so that those relationships are preserved, because it may be that this is an opportunity for vendors or customers who have a document that says any assignment of this document needs to be approved. And so basically, when you sell a company, you're assigning those contracts. That's an exit, that's an escape hatch for those contracting parties potentially. So all those things need to be considered earlier on, and then followed through in making sure that those customers are going to stay on board and that they are going to sign, you know, they are going to give their consent to the assignment to the new party, which is the buyer. So kind of went off on a tangent a little bit, but that's hopefully answered your question.
Well, this was pretty good, especially on the LOI, because that seems to be an area that gets downplayed, but it can bite you bad. So, you know, next week, it just seems to me like if we want to continue on with this theme, because there's plenty of stuff. One of the things I think that would be really beneficial, Adam, you've seen this, I know, and I won't mention the names of the companies, but where we had key employees that had shares of the company, some of them where it was handshake agreements, verbal understandings, other times where it was documented. Like, what do we do, like, so that we don't get to the point of, uh-oh, you know, what happens with those guys? You know, those details really matter. So I think, you know, key employees, internal shareholders, when those discussions come in, how do you deal with that? And
Yeah,
just moving into the due diligence, it seems like.
Yeah, that kind of hits, you know, a little bit of what I would also like to be able to share with the group is, you know, kind of what kind of planning do you need to do, tax planning do you need to do pre-transaction versus what can be done post-transaction, and that whole employee, like, what do I need to pay the employees, whether it's phantom stock, real equity, you know, how that calculation occurs to then result in a tax answer is something you need to do pre-transaction. So that's good.
Yeah, so I think that's where we'll kind of transition it to next week. So we'll continue on with this theme of examining the anatomy of the deal. Just out of curiosity, Adam, this big thing that just blew up last night, how long from the time of the LOI until the, oh, we forgot, we didn't have any money, you know, how long Is that 90 days, 60 days?
It probably, I mean, initial discussions probably happened about a month before I knew about it. And I knew about it in February.
Yeah. Wow. Think of all the disruption that happened.
I know. I mean, we had,
6
a
months.
lot of work that went into it, so yeah, it's crazy.
Yeah.
Reminds me in college, my buddy Ross Thompson, ran up this massive bar tab, buying shots for everybody, ready to pay the tab. And I mean, literally got it, like we joked with him forever about it, got up at the end and said, by the way, I have no money pulled out of his pockets. Nothing but rabbit ears. Like, are you freaking kidding me? Yeah. I'm like, that's kind of what this felt like. Woo, rabbit ears.
Oh gosh.
Yeah.
That's a bad
Ross
dream,
Thompson,
man.
Sorry that I had to out you.
That's a lot of dishes to have to wash for several weeks, it sounds like.
Man.
Yeah, we had him, we covered him, but we never let him forget it.
Oh my gosh.
Yeah, speaking of which, I mean, that happened when we were 21 and I'm now about to be 49. So that says a lot for how long the institutional memory for that stiff bar tab stands.
Yeah. Yeah, that's a good due diligence question. Hey, have you ever, promised something really grandiose and then just didn't deliver?
Yeah.
That might be a good early warning red flag. All
right.
right. Well, everybody, thanks for joining us. We appreciate that. Hopefully we're providing value. Feel free to hit us with questions though, in the meantime too, even next week or between now and next week, feel free to hit me so that we can tee those things up too. We will put this up on the BGW YouTube channel later on today. Thank you for joining us. We'll see you next week, Lord willing. See y'all. Bye-bye.
All right,
Thank
see you
you.
guys. Bye.